So, very good evening, friends. I've already shared this PPT with you. So, let us today discuss some of the provisions regarding this code of conduct for IPs in IBC. These provisions relating to code of conduct for IPs, they are contained in regulations for IPs, insolvency professional regulations. And so, in this booklet, which has been issued by IBBI, this is a handbook on do's and don'ts. I think I have already shared the entire booklet with you, rather the compilation of booklets. There are 5-6 booklets which have been issued by IBBI, and you must go through all those booklets if the time permits. Definitely, I try to cover whatever is important in those booklets. So let us read this code of conduct word by word, and we will try to envisage situations where what sort of situations could be covered. So your participation is equally important in this session. So what it says that the code of conduct for insolvency professionals, it is specified in the first schedule under regulation 7(2)H of Insolvency and Bankruptcy Board of India, insolvency professional regulations. So there are regulations. So there are questions on regulations also, which we will be covering. But this is the code of conduct. So we will start with code of conduct and then we'll go on to the regulations, which are more general, and we know almost all those regulations. So these are the important aspects. First is the integrity and objective. So actually certain characteristics are envisaged or expected from an insolvency professional. That you should be a person of integrity and objectivity. Then independence. These are some of the traits which he is expected to possess. But we must be able to distinguish one trait from the other. That what is included in independence and impartiality and what is included in integrity and objectivity. So sometimes they are framing questions on this. Integrity and objectivity, then independence and impartiality, professional competence, representation of correct facts and correcting misapprehensions, timeliness, information management, confidentiality, occupation, employability and restrictions, remuneration and costs, and gifts and hospitality. So these are the 10 traits which are expected of an insolvency professional. So we'll go on one by one, and we will try to envisage situations what could be covered and what could not be covered in a particular trait, and how to identify a particular trait from the behavior of an insolvency professional. So that is the idea behind this class. Earlier, they were asking questions out of the disciplinary cases, but now the trend is to focus on this code of conduct. So it has been attempted here to explain the different clauses of code of conduct for the insolvency professionals for giving a broader outlook so that possible do's and don'ts can be indicated. This chapter of the handbook is designed for the purpose of creating awareness of the subject and all those things. Now, let us see this one by one. So this is the first trait, integrity and objectivity. So can anybody tell me what is the meaning of integrity and objectivity?
Integrity is honest, sir, being straightforward.
Yes. So an insolvency professional, he must maintain integrity by being honest, straightforward, and forthright in all professional relations.
And we can add the loyalty also. Integrity comes along with the loyalty towards the institution or organization.
No, actually, the concept of loyalty is between the master and servant. So here there is no concept of loyalty as such.
Yes.
So it is by being honest, straightforward, and forthright. An insolvency professional, while discharging his or her duties cast upon him or her under various provisions and rules and regulations in a capacity as IRP, RP, authorized representative, liquidator, bankruptcy trustee, may have to appoint various professionals to assist or support him or to comply with relevant provisions, rules, and regulations. So this is one of the duties that, okay, well, if you are appointed as an IP or if you are appointed as an IRP, RP, AR, liquidator, or bankruptcy trustee, then one of your duties is to appoint professionals also. Now, it is important for IPs that while appointing any professional, so it says you should be a man of integrity, objectivity, and तीसरा point क्या था इसमें? Integrity, objectivity, and
Independence and something. Impartiality.
integrity and objectivity. So it says that, okay, as an insolvency professional, you might be required to appoint various professionals. So what are the points you should take into account? You have to ensure, first of all, that such appointment is made in a very transparent manner by adopting due procedure, such as inviting quotations from some eligible persons. Suppose you have been appointed as an IRP and you appoint your sister-in-law as a valuer, or you try to appoint your relative as a professional. So that is the point basically. So you have to adopt the due procedure, inviting quotations from some eligible persons, due negotiations, defining the scope in a clear manner, because sometimes your actions are also subject to the scrutiny of the adjudicating authority. A person might complain to the adjudicating authority that, okay, this person was not straightforward, he was not honest in his approach. So then you might be required to prove that, okay, my lord, I adopted due procedure in appointing of professionals. I invited quotations from some of the eligible persons. I conducted negotiations also. And there was a clear definition of scope in a clear manner. So you have to demonstrate this thing in order to prove your integrity and objectivity. Second is, it does not result in any conflict of interest due to past or present professional or other relationship. So you have been an auditor, you have been a consultant to the CD, and now you have been appointed as IP or IRP or bankruptcy trustee or something of that sort. So there should not be any conflict of interest due to past or present professional or other relationship. Third is, the appointment is done on arm's length basis and the fees is commensurate with the scope of work. It's not that, okay, the work is very minimal, but the fees you are charging is abnormally high. So then also you will not be considered to be man of integrity and objectivity. An IP shall also monitor the work of professionals to ensure that the work is done as per the scope of work and within the timelines. So you have appointed professionals. You are all in all in the company. So you have to monitor the work of professionals also, that it is done as per the scope of work and within the timelines. It is needless to mention that IBC 2000 envisages time-bound processes, and maintaining timelines is very important. Apart from above, an IP, while dealing with any stakeholder of the corporate debtor, such as financial creditor, operational creditor, other creditor, shareholders, directors, employees, workmen, etc., shall be fair in his or her dealings. So you have to be fair in your dealings to all these persons who are the stakeholders. He or she must observe utmost care that in such dealings, the interest of all stakeholders are protected. And to the maximum extent possible, IP shall also maintain such documents, papers in support of the above, so as to substantiate matters if it is required in future. So this is the first point. So before we move on to second point, let us see what is covered here. Let us make brief notes of what is covered here. First of all, regarding the appointment, you have to take extra care that appointment is done and you can demonstrate that, okay, appointment were done on an arm's length basis after adopting the due process, etc. So first is regarding the appointment of professionals. Second is to avoid any conflict of interest. Then appointment as at an arm's length basis, and fees should be commensurate with the scope of work.
Sir.
Yes, please.
Yes, sir.
Okay. And an IP, and then you have to monitor the work of professionals also. That, okay, whatever they have been appointed for, they are doing their work within the scope of work and limitations, and you are fair to all the stakeholders. This is also important, and interest of all the stakeholders are protected. And to the maximum extent possible, IP shall also maintain such documents, papers in support of the above, so as to substantiate matters if it is required. Now, please give me an example that, okay, you want to file a complaint against an IP that, okay, he was not a man of integrity and objectivity. So what sort of allegations you can impose, or you can say allege on him? So what sort of allegations you can cast on him?
Undervalued transaction not reported.
Undervalued transactions. Okay. Mm-hmm. Anything else?
Colluding with the
Let us take it one by one.
creditors, sir.
First is the regarding the appointment. In appointment, what sort of allegations could be there? So he has appointed.
Appointment of relatives, sir. As you have given an example.
Appointed his brother as a registered valuer.
Mm.
Okay.
And he has not selected arm's length professional, sir.
Then
Yes,
conflict of interest. What could be the type of conflict of interest? Suppose you want to allege that, okay, there was a conflict of interest. So what sort of examples, what sort of illustrations you can give to the adjudicating authority that, my lord, there was a conflict of interest?
Partner of that auditor firms.
Okay.
So
Okay.
when the two
So we-
persons are there, benefit from one person, for them you are giving more advantage, sir.
Okay. Mhm.
Benefit
So
is
that is actually basically the discrimination amongst various stakeholders.
okay, sir.
Mhm. Mhm.
Yes,
But that is also covered in integrity and objectivity. It says that while dealing with the stakeholders, you should be fair in your dealings.
Mm.
So I think you have understood what is meant by integrity and objectivity. Next
Yes.
point. Because they are asking questions and they will give you some situations and they say that, okay, you identify. Second point is misrepresentation of facts. What is this? An insolvency professional must not misrepresent any facts or situations and should refrain from being involved in any action that would bring disrepute to the profession. So this is also covered in integrity and objectivity only. In integrity and objectivity, they have given 4 types of instances of integrity and objectivity. The first we have seen. Second is this point. An insolvency professional must not misrepresent any facts or situations and should refrain from being involved in any action that would bring disrepute to the profession. So what is given here? During the course of discharge of his or her duties as IRP, RP liquidator, he is required to interact with various stakeholders, professionals, authorities, potential resolution applicants. During such interactions, he is expected to be careful. He must provide factual information and situations which he believes to be correct after taking due care on the authenticity of such information or situation. IP must not provide false information or misleading information to any of the persons listed above. Who are the persons listed above? Stakeholders, professionals, authorities, potential resolution applicants. Then IP should also refrain himself or herself from involving in any such acts or actions which would bring disrepute to the profession. The list of such actions may include such things as favoritism, providing false information. So this is the second point. So any instances you can give, any examples you can give for this? That okay, he misrepresented certain facts.
Yes, sir. I can share my experience, sir, of valuation.
Yes.
I was given to evaluate the coal stocks of a power plant.
Okay.
After the liquidation was done, he said that my stock is not valued. So I was asked to make the valuation of the coal stock. But when I went there, suppose 3,000 tons of the coal lumps were there. Out of that, 100 tons was the coal waste, which was 8 years old coal. Other 2,000 were the coal waste reclaimed from the boiler, which has no value, and that is can be used for refilling in the plant, filling in the plant and roads, etc. It's hardly 100 or 200 rupees per ton is the rate, because transporting is very heavy. So I got it tested, everything. This was not disclosed by him that this is not coal, all coal. So I had to take due care to make the valuation.
Mhm.
so that the testings were done from the authorized labs and the calorific value was obtained and the
Mhm.
report was submitted accordingly.
Mhm.
So this was the thing where the due care was required for submitting the report there, sir.
Mhm. A very good instance.
It
Very
was
good
not
instance.
disclosed, everything was not
Mhm.
disclosed to the valuer.
Mhm. Right. And any point on any actions which would bring disrepute to the profession?
Sir, it is, I don't know whether it is to be said here or not, but
Mhm.
sometimes the fee, the fee being paid to the professionals,
Mhm.
there some mismanagement is there, that the higher quotations are taken and I mean something like that. Because
Mhm.
recording is going on, so I'll not speak that, but there is some
No, we can
mis-
put up the recording also. We can switch off the recording, no issues. Mhm.
yes, sir.
But the point here is that, okay, if you go there in an inebriated state, so you are appearing before the CD in a drunken state. So these are the things which bring disrepute to the profession. You are not behaving in a proper manner. So these even your personal acts, they could bring disrepute to the profession, because as a professional you are required to maintain certain degree of decency and behavior. So that
Using
also,
improper language.
yes, yes. The list of such acts may include such things as favoritism. You are providing false information, because even resolution applicants are covered here. So if you are engaging in some private communication with a potential resolution applicant and you are passing on some information to him, and okay, so that we may quote higher value, you are misrepresenting facts, like the one stated by Tavinder Pal Singh ji, that is okay, stocks was presented in such a manner that higher value may be ascribed to such stock, hiding the factual circumstances. So these could be some of the situations which could be covered here. Now the third point. So all these are included in integrity and objectivity. Third point is an insolvency professional must act with objectivity. So I think the first 2 points were more towards integrity. And now this point is towards objectivity in his professional dealings, by ensuring that his decisions are made without presence of any bias, conflict of interest, coercion, or undue influence of any party, whether directly connected to the insolvency proceedings or not. So you are objective. You are doing things without presence of any bias, conflict of interest, coercion, or undue influence of any party, whether directly connected to the insolvency proceedings or not. Because you have to carry out many processes, and such processes include conducting valuation of assets of the corporate debtor, appointment of professionals, calling invitation for resolution plan, conducting meetings of committee operators, recording proceedings of such meetings in the form of minutes of meetings, filing various reports at the adjudicating authority, taking various decisions while in order to keep the corporate debtor as a going concern, then selling assets of the corporate debtor, providing information to various stakeholders. So in all these actions, because definitely all these traits will be observed to your duties, which you are expected to perform in various capacities. So while carrying out the above processes, IP must be guided by the objective of the code and objective of that particular process. The decisions taken by IP and the dealings done by IP in various processes must be rational, fact-based as per the provisions of the code. In no case, IP should be bowed down or compromise his or her position due to bias, conflict of interest, coercion, or undue influence. So this is the point. Basically, there should not be any bias. So bias means unfair dealings. You are dealing with one person in one way and the other person in another way. Then conflict of interest, then coercion or undue influence. So this is the third point. Now, next point is an insolvency professional must disclose details of any conflict of interest to the stakeholders whenever he comes across such conflict of interest during an assignment. Okay. At the time when you took up the assignment, you were not aware that there is a conflict of interest, but you came to know of such conflict of interest at a later date. So you have to disclose these details. So it may be possible that there might be situations where at the time of commencement of any assignment or during the course of conducting such assignment, IP comes to know regarding a conflict of interest she has in the assignment. IP in such situations, immediately upon becoming aware of such conflict of interest, must inform such a conflict to all the stakeholders of the corporate debtor. Okay. What sort of conflict could be there? You are an unmarried person. Now, after some time, during the process itself, you get married. You could get married to anyone. So you get married to the daughter of a director of the CD. It could be possible. So in this case, there is a conflict of interest. So this conflict of interest must be disclosed to the stakeholders, because that was not the situation at the commencement of the assignment. That situation cropped up later. So similar situations, you could imagine that the conflict of interest could arise at a later date because of change in the relationship or due to change in circumstances. So such things could happen. And fourth point is, an insolvency professional appointed as an IRP, RPA liquidator should not himself acquire directly or indirectly any of the assets of the debtor, nor knowingly permit any relative to do so. So this is also important that, okay, because you are in charge of everything, so you should try not to acquire directly or indirectly any of the assets. Okay? There is an Audi car of the CD which is undergoing the CIRP, and you are very much interested in buying that car. So what do? You ask your brother to give quotations, or you ask your cousin to give quotations, and you try to indirectly acquire that car. Funds are transferred from your account to your cousin's account for purchase. So in such cases, you could be implicated and you could be accused of directly or indirectly trying to acquire that asset. So IP in his or her various roles is expected to maintain highest levels of integrity and honesty. Since IP is the one who is carrying on various processes, including sale of assets, he is aware of many insider things which others are not. Because you might be aware that, okay, this asset is less used, or it is of even the fair value or liquidation value is less than what is the value that could be fetched in the market. So in order to maintain utmost integrity and honesty, IP must not himself directly or indirectly acquire. So these are the situations of integrity and objectivity. Now, next point is independence and impartiality. What are the traits? An insolvency professional must maintain complete independence in his professional relationships and should conduct the insolvency resolution, liquidation, or bankruptcy process, as the case may be, independent of external influences. So, but all these traits are somewhat interrelated, because you might find that, okay, we studied all these things in integrity and objectivity also. But this independence and impartiality means that, okay, you are independent. Whenever you take any decision, that is not influenced by any external or internal influences. That is the point, basically. So you have to maintain complete independence and should conduct the insolvency resolution, liquidation, as the case may be, independent of external influences. Suppose there are three financial creditors. One of the financial creditors is an influential financial creditor. Maybe he is having 80% of the voting rights. But still, you should not be partial towards him, and you should be impartial and independent. So Code of Conduct expects from the insolvency professional that he must act independently in various processes carried on with him or her. He shall conduct the process and engage in professional relationship without the presence of any bias, conflict of interest, coercion, or undue influence of any party, whether directly connected to the insolvency proceedings or not. Suppose something is to, there was a disciplinary case where the decision regarding expression of interest, invitation for expression of interest, that draft was finalized by the COC. But PNB was one of the influential creditors because he was having, I think, 80 to 90% of the voting power. So PNB on its own did some amendments in the invitation for expression of interest, and the draft which was finally approved by PNB was released, and the adjudicating authority issued a show cause notice to IP that, okay, howsoever influential the financial creditor is, you should not side with him while taking decisions, and whatever draft has been finalized by the COC, you must go accordingly. So this is an instance of independence or being influenced by some influence. So you should be independent and impartial in your dealings. Next point is in cases where the insolvency professional is dealing with assets of a debtor during liquidation or bankruptcy process, he must ensure that he or his relatives do not knowingly acquire any such assets, whether directly or indirectly, unless it is shown that there was no impairment of objectivity, independence, or impartiality in the liquidation or bankruptcy process and the approval of the board has been obtained in the matter. So what it says, suppose your relatives are acquiring certain assets. So, but if it is through open auction, anybody can acquire. And if they are giving higher value, then there is no partiality and there is no bias. But still, wherever required, you have to take the approval of the adjudicating authority, particularly when you yourself want to acquire the certain assets or they are to be acquired other than through public auction. So there are certain requirements which you have already studied during liquidation or during bankruptcy process, the whenever private auction is done or whether public auction is done. But here it says that the approval of the board has been obtained. Sometimes what happens is actually this is the code of conduct. So code of conduct is expected to be at a higher pedestal, even than what the regulations say. Sometimes regulations may allow you certain things, but as a professional, you have to be extra cautious that you are not accused of any bias. So that is the point here. So here it says that you take the approval of the board also if it is required, whenever your relative is acquiring, because such things are subject to circumspection by the other parties. So they might allege that, okay, there was a bias, that, okay, you allotted this flat to your brother simply because he was related to you. So at that time, you have to, you will be required to demonstrate that, okay, my lord, there was no partiality. I had informed all the parties, I had disclosed the conflict of interest also, and I had approved the I had already obtained the approval of the appropriate authority wherever it was required. And I informed the board also. So where an IP in his role as liquidator or bankruptcy trustee sells assets of the debtor, it is natural that being at the helm of affairs, he is the one who is aware of any insider things which others are not. Therefore, to ensure IP must not allow himself or herself to knowingly acquire such assets directly or indirectly. He should try to abstain if possible. That is the point. Next point is, an insolvency professional shall not take up an assignment under the code if he or any of his relatives, any of the partners or directors of the insolvency professional entity of which he is a partner or director, or the insolvency professional entity of which he is a partner or director is not independent in terms of the regulations related to the processes under the code in relation to the corporate person, debtor, and its related parties. So you should refuse that assignment. If your relatives or partners or directors, they are directly or indirectly present there. So in order to protect integrity, independence, and objectivity of the profession, and to ensure that various processes envisaged under the IBC are carried out with utmost integrity, so IBC has stipulated certain restrictions on IPs. So there are restrictions. One on the appointment of professionals and appointment of IP also. So you have to take utmost care while accepting the assignment that stipulations in the regulations are duly complied with. And if you are of the opinion that there exists any relations as stipulated, you should not accept that assignment. Next point is, you have to disclose the existence of any pecuniary or personal relationship with any of the stakeholders. Suppose you have taken loan from a director because the director is having some independent business also. So you have to disclose the existence of any pecuniary or personal relationship with any of the stakeholders who are entitled to distribution under section 53 or 178 of the code, and the concerned corporate person, debtor, as soon as he becomes aware of it, by making a declaration of the same to the applicant, committee of creditors, and the person proposing appointment. So you have to ensure that if there is any pecuniary or personal relationship, you must disclose it. So you have to evaluate the relationship with various stakeholders on a continuous basis. And as soon as you become aware of the existence of a relationship, then you must disclose it by making a declaration of the same to the applicant, committee of creditors, and the person proposing appointment as applicable. Now, here, let us take a situation that, okay, CIRP of XYZ Limited is going on. One of the directors is having an independent business also, which is being run in the name of his son. So, son of one of the directors of the CD, which is undergoing CIRP, is going on. You are an insolvency professional. Now, you have taken a loan from the business entity, which is being run by the son of the director. So, in such a situation, what you would do?
Should not accept the assignment as such, sir.
Disclose
Okay.
the fact.
So will this come under pecuniary relationship disclosure?
Yes. हाँ, pecuniary relationship आ जाएगा, देख लीजिए,
Yeah.
देख लीजिए. So I think this. So whenever there is any pecuniary or personal relationship with any of the stakeholders entitled to distribution, so then you have to disclose. So sometimes disclosure is required. Sometimes you should not accept the assignment. So wherever there are direct restrictions on acceptance of assignment, then they are given in the regulations itself. But this code of conduct sometimes goes beyond the regulations also. Now, it will depend upon the type of relationship which you are having, and you have to demonstrate that, okay, there was no conflict of any interest, there was no bias towards such a director from whom or from the son of whom I have taken the loan. So, Rajsekharan ji, what is your view on this? You should not accept, or you should simply disclose and go on accepting the assignment?
We should be very careful for this. Very carefully we have to deal with these situations. As a banker, we face this type of several issues in this way.
Mhm. So it is here the answer is there. It is important for an IP to evaluate his relationship. So you have to evaluate the relationship and you should see whether it is having any conflict of interest. That is the point basically. And you have to evaluate such existence on a continuous basis. And you have to decide yourself that, and if you want that, okay, some disclosure is required, then you should disclose that relationship. And if you think that we should not accept the assignment, then you should not accept the assignment. So what are the circumstances in which you should not accept the assignment? Suppose you have taken, you are an insolvency professional, but you have taken a loan from, say, a person who is one of the stakeholders. Now, let us go to the restrictions on appointment. What do they say? Sandeep ji, padhiye ek baar jara. Restrictions.
Mainly it's a consortium advances. It happens that 3 bankers, 4, 5 bankers will be there. 2 bankers have the very good close relationship with the debtor actually. So we should be very, very carefully. We have to be for this. Consortium advances like the creditor coincided with the debtor actually.
चलिए बाद में क्वेश्चन आंसर करते हैं, कोई बात नहीं, अब आगे देखते हैं. An insolvency professional shall disclose as to whether he was an employee or has been in the panel of any financial creditor of the corporate debtor to the committee of creditors. So here also some disclosure is required. So whether he was an employee or he has been in the panel of any financial creditor of the corporate debtor to the committee of creditors and to the insolvency professional agency of which he is a professional member, and the agency shall publish such disclosure on its website. So sometimes, so you have to make a note whether what are the circumstances in which disclosure is required and what are the circumstances in which you should not accept the assignment. So if you have been an employee or if you have been in the panel of any financial creditor of the corporate debtor, so you have to disclose this thing to the committee of creditors and the IPA of which you are a member, and the agency shall publish such disclosure on its website. So here the importance of independence of an IP is evident. So it is expected that he must be fair to the stakeholders and he should not have any sort of bias or favoritism. So to ensure this thing, it makes it mandatory to declare whether an IP was an employee or has been on the panel of any financial creditor of the corporate debtor. So what could be the example of being on the panel of any financial creditor of the corporate debtor? So it means the CD is XYZ Limited and PNB is the banker. So you have been on the panel of that PNB. That is the point basically. You are the concurrent auditor for that bank. Now, whether you should accept that assignment or not, that is the point. Such a disclosure. So here there is no bar on accepting the assignment, but you have to disclose this actually. So because as you are a suppose
Sir,
just
but burden of proving, sorry sir.
Just a minute. So actually, suppose you are a chartered accountant. As a chartered accountant, you can conduct this concurrent audits also. Suppose you are a concurrent auditor for PNB. You are on the panel of PNB, and PNB is one of the financial creditors of that particular CD. Now the point is whether you should accept that assignment or not. So the bar here is not on accepting the assignment, but it is your duty to disclose this relationship that, okay, I am the concurrent auditor of this PNB Nariman Point branch, and PNB Nariman Point branch has advanced loans to this CD which is undergoing CIRP. So such a disclosure is required, and you have to disclose this to the COC and the IP.
Yeah.
That is the point. Priya Venugopal ji, you were saying something?
Yes, sir. But it also depends upon how influential that decision will be, sir. But if you are a concurrent auditor of PNB, that doesn't make you influential of that decisions which has been taken by the PNB, sir. So we have to see that also, and also you have to burden of proof lies on the IP, sir. If anything
no,
goes wrong,
but what if he has already disclosed whatever he was required to disclose? He made this disclosure to the COC, and he made this disclosure to the IPA also, and IPA published this disclosure on the website. So this is what is required actually if you are an employee or if you have been in the panel of any financial creditor of the corporate debtor. Suppose you were an employee of SBI Nariman Point branch, and now SBI Nariman Point, you were already employed, because some of the bankers, they are also passing this exam of insolvency professional, that they are practicing as insolvency professional. Now you have been appointed as IP or one of the CDs where this SBI Nariman Point has advanced loan, so it's the financial creditor. So there is no bar as such that you being an ex-employee cannot be an IP, but you have to disclose this relationship.
Disclosure is the best provision, sir.
Yes.
Sir, can statutory auditor, internal auditor, and company secretary also do that?
Yes, why not? No, you should not be the statutory auditor of that CD, but you can be the statutory auditor of the financial creditor. In that case, you have to disclose this. That is the point, basically. It says an employee or panel. So panel, actually panel, if you are in the panel, it may or may not be that you are undertaking the assignment. That is also the point here. An insolvency professional shall not influence the decision or work of the committee of the creditors or debtor or other stakeholders under the code so as to make. अच्छा, इसी में एक point और discuss कर लेते हैं 8A में. So here is a situation that XYZ Limited is undergoing CIRP. ठीक है? Now PNB Nariman Point is one of the financial creditors, and you are the statutory auditor of PNB Nariman Point. Now, whether you can accept this assignment or not, that is the point. The question here is, XYZ Limited is undergoing CIRP. PNB Nariman Point is one of the financial creditors who has advanced loan to this company, XYZ. You are the statutory auditor of PNB Nariman Point. Now, whether you can be an IP of this XYZ or not, that is the question.
Yes,
There is
by
no bar,
disclosure,
there
I
is
think.
no bar, but we should not accept. But there is no bar actually. But
We need to check
we should not
3 years
accept
criteria,
actually.
sir. Do we need to check 3 years criteria?
Even the management of the Sad Bank is not appointee, sir. Even the management of the said bank, the same bank, not same employee, not accepting actually.
Okay. So we'll try to frame some case studies on this after this discussion is over. Then we'll see.
Yes, sir.
Next point is an insolvency professional shall not, so we'll park this question for the timing and we can discuss it in the group, citing the relevant regulations. An insolvency professional shall not influence the decision or the work of the committee of creditors or debtor or other stakeholders under the code so as to make any undue or unlawful gain for himself or his related parties or cause any undue preference for any other person. So this is the point basically. So you should not influence the decision of the or the work of the COC or any other stakeholders. So integrity of IP and honesty is of utmost importance. So various provisions of the code aim at ensuring that IP shall act in an honest manner and maintain integrity of the highest level. So during the assignment, an IP shall not influence any decision of the stakeholders to make any undue or unlawful gains, either for himself or for his or her related parties. He shall also not engage in any practice to give any undue preference for any other person for undue or unlawful gains. So that is the point. And you should not adopt any illegal or improper means to achieve any malified objective. So these were some of the conditions of independence and impartiality. Next point is professional competence. So what it says, an insolvency professional must maintain and upgrade his professional knowledge and skills to render competent professional service. So now they are continuing professional education guidelines also. So any act keeps on evolving as per the various developments, amendments, interpretation of statutes by various judicial forums. In addition to this, various clarifications, explanations to various provisions are being deliberated in seminars or conferences. An IP is expected to keep any eye of such amendments and developments which are happening in the code. He or she must update himself or herself thoroughly with such developments, and IP must have up-to-date knowledge of the code so as to render his service in accordance with the law. IP is also expected to acquire and develop soft skills through attending various seminars, conferences, training, etc., which are necessary for efficient discharge of his or her duties. So actually, suppose you are not aware of the latest developments, and this lack of knowledge is reflected in your minutes. Suppose earlier there was some other provision, but now that provision has changed. But when you are writing the minutes of meeting of that COC, so you are quoting the old provisions only. So it means you are not, you may be accused of being professionally incompetent because you have not maintained or you have not upgraded your professional knowledge. That is the point basically. Then is representation of correct facts and correcting misapprehension. So first of all, you have to represent the facts in a correct manner. And if there is any misapprehension in the mind, because you are a communicator also, as an IP, you are a communicator also. And as a communicator, you are required to communicate through various means. You are convening the meetings, you are chairing the meetings, you are floating various communications. So, and you have to prove, you have to make this communication beyond any misapprehension. So an insolvency professional must inform such persons under the code as may be required of a misapprehension or wrongful consideration of facts. So this is one of the duties, that to provide correct information and facts to all the concerned persons under the code. Correct information and correct interpretation of facts is necessary so that the process is just to everyone. So therefore, it is expected of any IP that he or she, during course of any assignment, if he becomes aware of any misapprehension by any person or wrongful consideration of facts by any person, he must inform him. That okay? This is not the situation. IP judicially shall decide as to what is misapprehension or wrongful consideration of facts. So if there is any wrong consideration of facts or if there is any misapprehension, so he should clear it beyond doubt. That is the point basically. Next point is that an insolvency professional must not conceal any material information or knowingly make a misleading statement to the board, the adjudicating authority, or any stakeholder as applicable. So here again, the code of conduct talks about fairness of the process. What it says, that during the course of assignment, an IP is required to submit, provide report information, report dubious transactions as to the board, the adjudicating authority, or any stakeholder. So while doing so, he has to take utmost care that the information being submitted or provided is correct and not misleading. He must also ensure that all the material information is submitted, provided, and no information is concealed for any reason whatsoever. So because like information memorandum could be one of the documents through which information is communicated. This invitation for expression of interest could be another document through which information is being communicated. So similarly, this evaluation matrix, that could be another means of communication, because through these various forms, through these various issuances, through these various communications which you are entering into with various stakeholders, you are communicating certain facts, and they should not be capable of misapprehension. So that much you have to ensure. And if you feel that, okay, this fact might be subject to some misapprehension, then you should clear it. And you have to submit reports or provide information, report dubious transactions, etc. to the board, the adjudicating authority, or any stakeholder. Next point is regarding timeliness. An insolvency professional must adhere to the time limits prescribed in the code. Actually, for every day of delay, like in CIRP, the timeline is 180 days. The initial timeline is 180 days only. It is not 330 days, it is 180 days. Then you have to seek an extension for another 90 days. And then maximum 330 days if some time is lost in litigation. Naturally, there could be delay beyond that also. But in that case, you have to apply for exclusions. So the point is that you have to be, you must adhere to the time limits, and you have to account for every day of delay. The objective of the Insolvency and Bankruptcy Code is time-bound resolution. Hence, it is of utmost importance that the timelines prescribed under various provisions of the code and the rules, regulations, and guidelines are religiously followed so as to complete the process within the stipulated time. आप ये नहीं बोल सकते आज मुझे सिर दर्द था, आज मुझे पैर में दर्द था, ये हो गया, वो हो गया, ऐसा नहीं। तो आपको क्या करना है, आपको टाइमलाइंस के हिसाब से चलना है। जो टाइमलाइन दे रखी है उनके हिसाब से ही आपको चलना है। मतलब एक दिन का भी डिले जो है ना, उसको भी आपको एक्सप्लेन करना पड़ेगा कि भाई वो क्यों है, इसलिए। हाँ, so you have to carefully plan your work because you already know what is the timeline, and promptly communicate with all stakeholders involved for the timely discharge of his duties. Because various model timelines have been prescribed, and so IP shall chalk down a calendar of various activities which are required to complete the assignment, because you have to break down the activity into various components. So, and accordingly, you have to chalk down a calendar of various activities which are required to complete the assignment along with the maximum time available for each activity. So IP shall carefully plan his actions, deploy his resources to ensure that the timelines are adhered to. And there are certain tasks or activities which are dependent on certain stakeholders. So IP shall clearly communicate with such stakeholders and request them for adhering the timeline. So those things are also important, because sometimes bankers, suppose the resolution is there for approval of the resolution plan. So in such case, sometimes bankers, they take too much time that, okay, we'll be seeking our consent from the head office, approval from head office. So in such cases, you are expected to be continuously in touch with the various stakeholders so that the timelines are adhered to, because you have to account for every day of delay. An insolvency professional must not act with malefied or be negligent while performing his functions and duties under the code. So you are expected to be straightforward, transparent, honest, and independent manner. Further, while discharging various duties, you have to be vigilant and alert. You cannot be lax in your approach. So you have to be vigilant and alert. Now is the information management, because you are the communicator. So if you, whenever you enter into any communication, whether in the form of notices, reports, updates, directions, or clarifications, so you have to make them well in advance and in a manner which is simple, clear, and easily understood by the parties involved, by the stakeholders. So that is, you have to ensure by the recipients. So what it says, for meaningful use of any information, apart from being conveyed, it is also important that the information must be provided well in advance and in a way which is simple, clear, and easy to understand to the recipient. So while discharging various duties in an assignment, IP is required to communicate to various stakeholders. For example, notice and agenda of meeting of committee of creditors, a report to be filed at board and adjudicating authority. So these are the various things. Information. Just a minute. To be provided to the resolution applicants. So in such communication or exchange of information, IP must take care and ensure that information is provided well in advance and in a manner which is simple, clear, and easy to understand to the recipient. So there should be clarity on these points. Next point is an insolvency professional. An insolvency professional must ensure that he maintains written contemporaneous records for any decision taken, the reasons for taking the decision, and the information and evidence in support of such decision. This shall be maintained so as to sufficiently enable a reasonable person to take a view on the appropriateness of his decisions and actions. Because now when you are acting as an IP, you are taking various decisions. So these decisions are subject to circumspection because various stakeholders are involved, and some stakeholder might complain to the adjudicating authority that, Lord, he was not appropriate in taking his decision. So then you might be required to prove these things. And that could be the time when this assignment is already over, say 2 years or 3 years ago, because there is a record retention period also. So the whatever decision you have taken and what was the basis of taking that decision, all that information, papers should speak for themselves. That is the idea basically. So you have to ensure that you have to maintain written contemporaries, because sometimes certain verbal things are there, but you have to put them on record. Written contemporaneous records for any decision taken, the reasons for taking the decision, and the information and evidence in support of such decision. This shall be maintained so as to sufficiently enable, because sometimes you might be required to reconstruct the events. Adjudicating authority might call you 2 years after the assignment is over that, okay, what was the basis for taking this decision and why why disciplinary action should not be taken against you. Acha, इसी से एक याद आ गई बात, क्या is there any time period within which this disciplinary action can be taken? Suppose you completed an assignment in 2020. So then by what time the adjudicating authority can issue you show cause notice? कोई टाइम पीरियड है क्या, या असाइनमेंट खत्म हो गया तो खत्म हो गया, कैसे होगा?
6 months, sir. Within 6 months.
8 years तक documents retain करने.
6 months, and the fees is 2.5K, and it is required to be filled in Form B.
No, वो बात नहीं मैं पूछ रहा, मैं वो बात ही नहीं पूछ रहा, मैं क्या पूछ रहा हूँ? What I am asking is, okay, you were appointed as an IP in 2018. Okay, you completed that assignment in 2020. Now, can IBBI issue you notice in 2023? That is my question.
Yes, sir. Till 8 years, I think.
What section 220 says on this? Because 220 talks of inspection, investigation, etc., and issue of disciplinary notice. So, please discuss this thing in the group. That up to what time? Yes, I also agree that, okay, whatever is the record retention period, so by that period, action can be taken. And suppose that could be an offshoot of some other decision also. Suppose this matter was under court, and the court, while going through those records, they called you as an IP. So that way also you might be required to produce the documents. And as far as the record retention period is there, and even beyond 8 years, you might be required to keep the records. What is the situation? ये किस situation में रखना है आपको? 8 साल के आगे भी आपको रखना पड़ सकता है, अगर सिर्फ सब court process is going on. तो जब तक
Litigation
वो
is going on.
yes, if some litigation is going on, तो जब तक वो litigation नहीं खत्म हो जाता तब तक रखना है आपको. अब अगला पॉइंट देखते हैं. Yes,
It's
please.
like section 148 of our IT Act, sir.
Okay.
They can go beyond, yes, no, sir.
Okay. An insolvency professional must not make any private communication with any of the stakeholders unless required by the court, rules, regulations, and guidelines thereunder, or orders of the adjudicating authority. So what it says that whatever communication you are entering into, that should be public communication. It's not that one of the resolution applicants is calling you in the evening after office hours and privately communicating with you, and you are secretly communicating to him the liquidation value or fair value or any facts which are not available, or that particular person only is just privy to that communication. So all communication should be clear and there should not be any private communication. So various assignments an IP undertakes under IBC include legal processes. It involves interest of many stakeholders because there might be 4 resolution applicants. And if it is proved that, okay, you were in touch with one particular resolution applicant and you were passing on some classified information to that resolution applicant, then you might be accused. So it is the legal duty of IP to ensure that to protect the interest of all the stakeholders. Being a legal process, an IP must not make any private communication with any of the stakeholders. So all the communications must be official and duly recorded. However, if certain private communications are specifically required under the code, rules, regulations, and guidelines thereunder or pursuant to such orders by the adjudicating authority, in such case, IP may do private communication. Except these, IP must not involve any sort of private communication. तो ऐसा कहाँ लिखा है? कहीं लिखा है कि प्राइवेट कम्युनिकेशन भी आप कर सकते हो? ये बोलता है जहां पर कोड ने बोला हो तो कर दो. Just a minute.
Thanks, sir. Nothing as such
I
mentioned.
think stakeholder के साथ लिख
Yeah, Yuvraj ji, what are you saying?
stakeholder committee में के साथ liquidation में कर सकते हैं, but वो have to
That is
maintain the
required to
code
be
of the
recorded
same.
for me. Yeah.
क्या बोला आपने?
Sir, stakeholder committee के साथ कर सकते हैं किसी one stakeholder के साथ, but we have to maintain record for the same.
Okay. Also, wherever permitted by the code, you can do it. Next point, an insolvency professional must appear, cooperate, and be available for inspections and investigations carried out by the board, any person authorized by the board, or the insolvency professional with which he is enrolled. So you have to be open to the communication. An IP has been entrusted with a critical work and is expected to maintain highest levels of integrity, honesty, transparency, fairness in his dealings. The work of IP are subject to inspections and investigations by the board, any person authorized by the board, or the insolvency professional. So he is subject to 2 agencies, IBBI and the IPA, with which he is enrolled. So it is your duty to cooperate with such inspections and investigations where it is conducted. He must appear before such persons which are conducting inspections and investigations. It is important for an IP to maintain all records supporting and substantiating his or her work, which will be helpful in such inspections and investigations. Any sort of non-cooperation or insufficient supporting documents may lead to penal action. So that is also the point which is covered in communication. Then an insolvency professional must provide all information as may be required by the board or the IPA. So an IP is expected to maintain all relevant records and information to the assignments for the assignments handled by him or her. Upon being called for, IP shall immediately provide for such records and information to the board or IPA with which is enrolled. Next point is an insolvency professional must be available and provide information for any periodic study, research, and audit conducted by the board. So if the board is conducting any periodic study, research, or audit, then you must be available and you should provide the information whatever is asked for. So in its endeavor for professional enrichment and continuous professional knowledge updation and or for other relevant purposes, the board may carry out various periodic study, research work, and audit of assignments conducted by the IPs. During such study, research work and audit, an IP must fully cooperate, provide information, and make himself herself available for such processes. Next point is regarding confidentiality. An insolvency professional must ensure that confidentiality of the information relating to the insolvency, bankruptcy is maintained. However, this shall not prevent him from disclosing any information with the consent of the relevant parties or required by law. So actually, you have to maintain confidentiality, and sometimes you are required to obtain an undertaking of confidentiality also. So IP in his or her various roles undertakes very delicate work. The role of IP is fiduciary. IP primarily is trustee of all stakeholders. IP has to protect. So they can frame questions like this. IP is trustee, yeah, beneficiary, yeah, or bhi kuch. IP has to protect interest of all stakeholders. In order to ensure this, IP must maintain confidentiality of the information and records possessed by him or her during insolvency, liquidation, or bankruptcy process, and should not disclose any confidential information to anyone. However, although IP must maintain confidentiality, it does not stop him from disclosing relevant information with the consent of the relevant parties or as it may be required under any law. Taken. Agla point देखते हैं. Then occupation, employability, and restrictions. So an insolvency professional must refrain from accepting too many assignments if he is unlikely to be able to devote adequate time to each of his assignments. Now there is a restriction also that you cannot take more than 10 assignments, out of which 3 should not be more than कितना है उसमें 500 crore है 1000 crore है 1000 crore है ना
1000 crores, sir.
हाँ वो भी CIRP में लिखा ना वो उन्होंने
CIRP.
हाँ. So accordingly you have to do. Then an insolvency professional must not engage in any employment when he holds a valid authorization for assignment. So if you are holding a valid AFA, then you should not be in job or when he is undertaking an assignment. So because this work requires full-time dedication, so you should not be in job when you are performing any assignment. The code of conduct has clarified here that an IP must not engage in any employment when he holds a valid AFA or when he is undertaking an assignment. Next point is where an insolvency professional has conducted a CIRP, he and his relatives shall not accept any employment other than an employment secured through, this is also important. Actually, there is a certain time period also within which you should not accept any assignment. Suppose you have conducted a CIRP. Now your son is employed with that particular company after resolution. So when an insolvency professional has conducted a CIRP, he and his relatives shall not accept any employment other than an employment secured through open competitive recruitment with or render professional services other than services under the code to a creditor having more than 10% voting power, the successful resolution applicant, because these are the persons to whom you were able in a position to give benefit. So you might have given them some direct or indirect benefit, and now they are obliging you. So that should not be the case. So neither you nor your relative should not accept any employment. If it is through open competitive recruitment, then it's okay. And then you should not render also professional services to a creditor.
Sir, one clarification, sir.
Just a minute. Through this, एक minute. To the success, let me complete. To the successful resolution applicant, the corporate debtor or any of the related parties until a period of 1 year has elapsed from the date of his cessation from such process. ठीक है, 1 साल आपका हो गया, CIRP कंप्लीट हुए, उसके बाद में आप कर सकते हो, उससे पहले नहीं. Yes, please. हाँ जी बोलिए. कुछ
सर
बोल
वो
रहे थे?
ये तो सर जिसे ASA नहीं मिला बट साइट में करेक्ट हो गया, ऐसा एक क्वेश्चन आया था सर. उनकी इंटरनेट साइट में करेक्ट हो गया कि योर डिसिप्लिनरी एक्शन इज ओवर एंड नहीं सॉरी आपका रजिस्ट्रेशन इज रिन्यूड बट उसका ASA नहीं मिला सर उसको. सो कैन ही डू दैट इन दैट केस? साइट में उनका नाम ओके हो गया सर.
हाँ हाँ
बट IBBA के साइट में नाम ओके हो गया
मतलब AFA
ASA नहीं मिला मगर
AFA,
हाँ, हाँ,
AFA.
AFA अच्छा,
Yeah.
ऑथराइजेशन फॉर असाइनमेंट की बात कर रहे हैं ना आप?
ये सर
हाँ,
ASA
तो
नहीं
अगर
मिला,
साइट पे अपडेट हो गया तो कर सकते हो, फिर तो क्यों नहीं कर सकते आप?
ये सर वो
वो
मिला।
तो क्या है, वो कुछ भाई मिसकम्युनिकेशन होगा, ईमेल नहीं मिला होगा, ईमेल बाउंस बैक हो गया, या कुछ भी हो सकता है।
राइट सर, राइट।
टू टेक एनी एम्प्लॉयमेंट, तो ये यहाँ
सर-
पर ये है कि अगर कोई, जस्ट मिनट, कोई सक्सेसफुल रेजोल्यूशन एप्लीकेंट है, तो क्रेडिटर है, whom you were in a position to influence, ठीक है ना? तो इसमें there are two exceptions, one is through open competitive process and second is after 1 year from the process. हाँ प्लीज, कुछ क्वेश्चन पूछ रहे थे, कोई पूछिए, क्या पूछ रहे थे?
हाँ सर, एक सिचुएशन ऐसे दिमाग में आ रही थी, मान लीजिए ABC some hospital which is going under CIRP
ठीक है,
and Mr. X is appointed as a RP of that CIRP process
ठीक है,
and spouse of X has been is undergoing some cancer treatment
ठीक है,
and that treatment is being done in that hospital on credit basis which is not under the normal policy of the hospital.
ओके,
It is not free of cost, but it is on credit basis. In
Uh-huh.
that situation, what the RP should do?
भाई देखो, he has to weigh the options, whether there is any conflict of interest, whether there is any favor which is extended. Ultimately देखो, अगर if he pays, जैसे कई बार क्या होता है, suppose you are trustee in a school and your children are also studying the same school, तो ऐसा हो जाता है कि नहीं? तो इस तरह से अगर ये in some cases in income tax also there is a provision that okay, if you are a trustee in a hospital and you are being given some benefit, so then वो situation, you have to weigh the situation and accordingly disclose. अगर आपको disclose करने का जरूरत है तो आपको disclose करना है.
Sir, disclosure in this case should be mandatory, I think, because
हाँ,
it
तो
is not in
disclosure
the
आप,
general normal.
हाँ तो
policy
ठीक
of
है,
the
अगर आप
hospital.
नॉर्मल पॉलिसी में नहीं तो आपको COC को डिस्क्लोज कर देना पड़ेगा, IPA को डिस्क्लोज कर दो. डिस्क्लोज करने में क्या है? डिस्क्लोज करने के बाद तो कोई एलिगेशन लग नहीं सकता आपके ऊपर.
After that, he can continue to be the RP. of
हाँ,
that
क्यों नहीं, क्यों नहीं. हाँ, और भाई सपोज इट इज द ओनली हॉस्पिटल, कई बार होता है एक सिटी में आप रह रहे हो, उस सिटी में हॉस्पिटल ही वही है, सबको वही जाना पड़ेगा. अब ये थोड़ी कि आप हॉस्पिटल में जाओगे ही नहीं, ऐसा तो नहीं है ना.
But the credit extended is the abnormal some.
हाँ, अगर
out of-
एबनॉर्मल है तो देन यू हैव टू डिस्क्लोज,
Yes, yes.
या फिर आपको एक्सेप्ट ही नहीं करना चाहिए, क्योंकि इट विल कम इन द नेचर ऑफ गिफ्ट आल्सो. हाउएवर द
After
हाँ.
acceptance, it has come to this situation.
However, the above employment may be undertaken during this period, which is secured through open competitive. ठीक है, तो ये भी हो गया. अब अगला चलते हैं. An insolvency professional shall not engage or appoint any of his relatives or related parties for or in connection with any work relating to any of his assignments. ठीक है भाई, अपने रिश्तेदारों को, रिलेटेड पार्टीज को थोड़ा दूर रखो, ठीक है, क्योंकि इंडिपेंडेंस और फेयरनेस आपको इंश्योर करनी है. अब अगला करिए. An insolvency professional shall not provide any services for or in connection with the assignment which is being undertaken by any of his relatives or related parties. दोनों ही बातें हैं भाई. एक तो ये है कि आपको अपने रिलेटेड पार्टीज को या रिलेटिव्स को एम्प्लॉय नहीं करना है, एंड सेकेंडली यू शुड ऑल्सो नॉट टेक एनी असाइनमेंट where which is undertaken by any of your relatives or related parties. So this is a similar situation. और ये आपको कहां से देखना है? 524E से देखना है, 524 से देखना है. नेक्स्ट देखिए. An insolvency professional must not conduct business which in the opinion of the board is inconsistent with the reputation of the profession. ठीक है, आप कोई प्रॉपर्टी डीलर का काम कर रहे हो, ठीक है ना, या आप कोई और इस टाइप का काम कर रहे हो which is inconsistent with the reputation of the profession. So an IP is the backbone of the IBC 2016. So he is the one who runs the entire process. He has been entrusted to protect the interests. You are working in fiduciary capacity and you are the trustee of all the stakeholders. So you must command good reputation. Okay? The regulations require a person applying for registration as IP to be fit and proper person. ठीक है ना? तो अब इसके लिए क्या है कि भाई an IP before undertaking any business you must take prior approval of the board. भाई कई बार क्या होता है, आपकी HUF है, आपको कोई फैमिली बिजनेस है. अब आपके फैमिली बिजनेस में आप ये तो नहीं कह सकते भाई मैं फैमिली बिजनेस में पार्ट नहीं करूंगा या मैं वहां डायरेक्टर नहीं बनूंगा. तो ऐसा कुछ है तो आपको क्या अप्रूवल ले लेना चाहिए बोर्ड से प्रॉपरली, अगर आप कोई बिजनेस कंडक्ट कर रहे हो जो बिजनेस में आता है. नेक्स्ट पॉइंट आता है रिमनरेशन एंड कॉस्ट्स. remuneration and cost, and sometimes there is a prohibition also. कई बार जैसे as a chartered accountant you cannot engage in particular type of business, ठीक है ना. कुछ businesses allowed हैं, जैसे वो derivatives वगैरह का business allowed है, but और बाकी businesses allowed नहीं है. आप चाहो भाई आप कोई प्रॉपर्टी डीलर का बिजनेस कर लो, वो नहीं अलाउड आपको. तो आपको क्या करना है कि जो अगर आपका बिजनेस कुछ इस टाइप का है तो आपको अप्रूवल बोर्ड लेना चाहिए, प्रायर अप्रूवल ऑफ बोर्ड लेना चाहिए, ठीक है. Remuneration and cost. An insolvency professional must provide services for remuneration which is charged in a transparent manner, is a reasonable reflection of the work necessarily and properly undertaken, and is not inconsistent with the applicable regulations. So this was the favorite of the examiners. इस पे examination बहुत सवाल पूछते थे, एक IP है और उसने अपनी वाइफ को CD के बहुत सारी assignments दिला दी, तो वो यहाँ पर आ जाता है remuneration and cost. ऐसा नहीं कि आप उसको लूटने पे आ जाओ. बहुत सारी जगह ना रिकमेंडेशन लिखी नहीं है, कितनी है भाई, आप 5 लाख लेनी है, 5 करोड़ लेनी है, बट वो क्या है, वो फिर आपको बहुत सारी चीजों से जज करते हैं. भाई पिछली ITR दिखाओ आपकी, ठीक है भाई, पिछली ITR आप क्या है, मान लो आपने पिछली ITR में 5 लाख रुपए आपने ITR भर रखी थी, अब आप कह रहे हो जी मेरी फीस 5 करोड़ है, ठीक है ना. तो इस तरह से IBC 2016 and rules and regulations made thereunder does not have any provision on the professional remuneration. Professional remuneration is nowhere written, ठीक है ना, हो भी नहीं सकती, because different businesses have got different needs. So although there is certain percentage of remuneration prescribed for liquidation, but that is also subject to decision of COC, ठीक है ना. So as such the remuneration is suggestive. So this COC is free to decide the remuneration in other manner also. However, an IP shall charge remuneration which shall be commensurate with the work involved, ठीक है. The remuneration should be fair reflection of his or her time which he is devoting, है ना. It should not be exorbitant. Just a minute, 1 minute complete कर लूं. The remuneration shall depend on assignment to assignment basis. The remuneration must be clearly defined in a transparent manner, and there should not be any sort of ambiguity or contingency in any. Yes, please. अब बोलिए.
सर उस केस में क्या आंसर रहना चाहिए जो अपनी वाइफ को असाइनमेंट्स दिला देते हैं फिर?
हाँ भाई देखो, असाइनमेंट दिलाने पे कोई बाहर तो नहीं है, बट ये है कि आपका जितना रिकमेंडेशन मिलना चाहिए उतना ही मिलना चाहिए उसके हिसाब से.
सर असाइनमेंट्स फिर किसके नाम में जाएंगे, वाइफ के नाम में जाएंगे या उसके नाम में जाएंगे?
भाई देखो, अगर हस्बैंड वाइफ दोनों प्रोफेशनल्स है तो दोनों असाइनमेंट्स ले सकते हैं, कोई ऐसा बाहर तो है नहीं कि नहीं ले सकते, ऐसा तो कुछ बाहर नहीं है भाई, कोड में तो ऐसी बात लिखी नहीं है. तो वो तो ये है कि भाई देखो, ऐसा है जिसने आपको ये असाइनमेंट दिलाई उसने भी और हो सकता है औरों से भी कोटेशन ली हो, ऐसा भी तो हो सकता है ना. उसने औरों से भी कोटेशन ली हो, या फिर आपसे ही कुछ इन्फॉर्मेशन मांगी हो, आपसे स्कोप ऑफ वर्क पर डिस्कशन हुआ हो, वो पूरी चीजें बताएगा ना आपको कि भाई कितना टाइम इन्वॉल्व है, टाइम के हिसाब से वो देखेगा कि फिर आपकी कितनी कॉस्टिंग आएगी. आपने हो सकता है कोई कॉस्ट शीट दी हो, तो आपको जस्टिफाई करना पड़ेगा, मेन बात तो ये है.
ठीक ठीक ठीक.
अब अगला देखते हैं. An insolvency professional shall disclose the fees payable to him, the fees payable to the insolvency professional entity and the fees payable to professionals, ठीक है ना. ये आपको बताना है किसको, IPA को, ठीक है, जिसके साथ आप एनरोल्ड हो. सो यू हैव टू डिस्क्लोज दिस थिंग. ये फॉर्म्स है, फॉर्म्स में आपको डिस्क्लोज करना है और IPA विल डिस्क्लोज इट ऑन द वेबसाइट, ठीक है. अब अगला देखते हैं. An insolvency professional shall not accept any fees or charges other than those which are disclosed to and approved by the persons fixing his remuneration. इसका मतलब यह है कि आपको अंडर हैंड कुछ नहीं लेना है, अंडर द टेबल कुछ नहीं लेना है. आपको जो भी चार्जेस लेने हैं वो डिस्क्लोज होने चाहिए और अप्रूव्ड होने चाहिए. कई बार क्या होता है, सपोज यू आर ऑपरेटिंग द बैंक अकाउंट ऑफ द CD, तो ऐसा नहीं कि बैंक अकाउंट में से आप ही अपने नाम में चेक काटते हैं, ऐसा नहीं है, ठीक है ना. उसके लिए आपको डिस्क्लोजर भी देना है और अप्रूवल भी लेना है. So an IP shall fix remuneration, fees or charges with the applicant or COC, which shall be commensurate with the work involved in the assignment. Remuneration should be fair reflection of his time deployment and resource deployment. Okay? It should not be exorbitant. And once fees or charges are fixed and approved by persons fixing his or her remuneration, so IP shall not charge any other fees or charges under whatsoever name. ठीक है. If there are some other charges or fees which are necessitated due to change in scope or circumstances, so first you get it approved, ठीक है, then only you can charge. Next point is that you have to disclose all the costs towards the insolvency resolution process cost, liquidation cost, cost of bankruptcy process as applicable, to all relevant stakeholders and must endeavor to ensure that such costs are not unreasonable because you are being paid first in priority. तो जितनी भी आपकी कॉस्ट है, जो भी इंसॉल्वेंसी रेजोल्यूशन में, लिक्विडेशन में लगी, बैंक्रप्सी में लगी, ये आपको प्रॉपर उसका डिस्क्लोजर देना है टू ऑल द रिलेवेंट स्टेक होल्डर्स, और आपको उनको रीजनेबल रखना है, अनरीजनेबल नहीं होना चाहिए. ठीक है, अब आगे चलते हैं. अगला गिफ्ट्स एंड हॉस्पिटैलिटी. तो ठीक है, आपको कुछ गिफ्ट्स वगैरह एक्सेप्ट नहीं करने हैं. ऐसा नहीं भी कोई दिवाली पे आके आपको गिफ्ट दे रहा है डायरेक्टर कंपनी का, आपको एक्सेप्ट ही नहीं करना. ठीक है. NIP has to ensure highest levels of integrity, independence, transparency and fairness of the processes he or she undertakes. या कोई रेजोल्यूशन एप्लीकेंट आपको दिवाली गिफ्ट दे रहा है, under various provisions of the code, NIP shall only receive the remuneration which has been fixed by the approving persons. The remuneration shall also be commensurate with the work. In addition to the remuneration, NIP or his relative must not accept any sort of gifts or hospitality which undermines or affects his independence as an IP. ठीक है.
One question.
हाँ जी.
IP cannot accept gift. Can IP give gift to COC or maybe financial creditors?
नहीं, why should he give?
No.
देखो, ऑब्जेक्टिविटी कोई जरूरत ही नहीं है. Why should he give? He should act in a transparent manner.
हाँ सर, मैं आगरा घूमने गया, आगरा से पेठा लेके आया COC के लिए. Can I do that?
देखो, उसमें इतनी कोई दिक्कत वाली बात नहीं. आप 100, 200, 500 रुपए की कोई चीज ले आए, वो तो आप अपने नौकर को भी दे देते हो, उसमें क्या है? वो ऐसा कुछ नहीं है. देखो, वैल्यू इज ऑल्सो इम्पोर्टेंट, कि उसकी वैल्यू कितनी है वो भी तो इम्पोर्टेंट ना. आप ये नहीं कह सकते भाई सबके लिए डायमंड का नेकलेस ले आए रेजोल्यूशन एप्लीकेंट के लिए, या रेजोल्यूशन एप्लीकेंट ने आपकी वाइफ को डायमंड का नेकलेस दे दिया. वो नहीं होना चाहिए.
Got it, sir.
हाँ. एन इंसॉल्वेंसी प्रोफेशनल शैल नॉट ऑफर गिफ्ट्स और हॉस्पिटैलिटी. देखो, ऑफरिंग पे भी आ गया, पहले तो एक्सेप्ट, ये ऑफर पर आ गया. ऑफर गिफ्ट्स और हॉस्पिटैलिटी और ए फाइनेंशियल और एनी अदर एडवांटेज टू ए पब्लिक सर्वेंट. ठीक है भाई, आप एडजुडिकेटिंग अथॉरिटी के पास पहुंच गए, आप NCLT में जो रजिस्ट्रार है उसके घर पे पहुंच गए दिवाली पे, उसको आप सोने के कॉइन्स दे आए, तो ये नहीं होना चाहिए. और एनी अदर पर्सन इंटेंडिंग टू ऑब्टेन और रिटेन वर्क फॉर हिमसेल्फ और टू ऑब्टेन और रिटेन एन एडवांटेज इन द कंडक्ट ऑफ प्रोफेशन फॉर हिमसेल्फ. ठीक है ना, तो ये भी आपको नहीं करना है. To achieve this, NIP must not indulge in any activity which will result in compromise of his independence and or bring disrepute to his noble profession. Hence, NIP shall not offer gifts or hospitality or a financial or any other advantage to a public servant or any other person intending to obtain or retain work for himself or to obtain or retain an advantage in the conduct of profession for himself. ठीक है जी. तो बस
Sir?
इतना ही था. जस्ट a minute. Yes, please. बोलिए.
Sir, in this remuneration and cost, you told that that IP should inform the IPA and IPA will publish in the website, sir. Whether such information can be been published in the website, sir? Any?
No, there are forms for that. No? There are forms for that actually. So on a periodical basis, you have to inform them. And you are required to share a certain percentage also with IBBI.
Yes, sir.
After the end
But
of
it
each year.
is okay. That is nothing as saying, I mean, ethics or something like that. So normally that fees obtained by a professional, whether it can be disclosed in the site, sir. Just I'm
No,
asking.
that is actually to ensure transparency. That is actually to ensure transparency and to set some benchmarks also. Suppose then tomorrow the IPA may say that okay, for such and such work, such and such fees is charged by most of the professionals. So why you are charging? Why you are overcharging? So that could be the point actually.
Okay.
So whatever is written in the regulations, you have to follow it.
Yes, sir. Okay, sir. Thank you.
So I think we can stop here. कोई और किसी का कोई क्वेश्चन हो तो, otherwise what we can do is आप भी you also share your experience because most of you might have already appeared and you might have got this case study on professional ethics. So you can post the questions in the group so that we can frame 3-4 case studies on this. Our endeavor should be to frame at least 4 case studies on these professional ethics. So you please share your questions. You can share them privately also to me if you don't want to share in the group, or you can share it in the group also, whatever way you feel like. But contribution should come from all because almost all of you have already appeared in the exam. So that is the point basically.
Okay, sir.
है ना?
Yes, sir.
Right, sir.
Okay जी, good night.
Thank you, sir.
Good night, sir. Good
And
night
good
to
night.
all.